back again. This is part 2 of the video lecture for defenses to negligence for Law 1204. And so we're just moving on to the third defense, which is illegality, and that starts at slide 10 in your textbook, in the PowerPoint presentation that you have available to you on DC Connect. So in the defense of illegality, essentially means you can't recover damages that you're trying to claim if you were injured by another party who was acting negligently, if you were engaged in an illegal act at the time. So your engagement in that illegal act essentially nullifies you or bars you from claiming damages to any negligent act that might have occurred against you. So there's the Latin terminology for it on the slides as well, which I'm not even going to try to pronounce for you because I'll probably butcher it. But the quote that comes out of the Latin translation into English is: an action does not arise out of a shameful cause. An action does not arise out of a shameful cause. So if the plaintiff has participated in some kind of shameful or illegal activity and is injured, they have no claim against the defendant who caused that injury. Illegality is also a whole defense, so it completely covers or blankets that defendant from any liability. So this would work in the sense that once a claim is raised against the defendant for a negligent act, the defendant would raise this as their defense. They'd say, hold on a second, whether or not I was negligent doesn't really matter. The plaintiff was engaging in illegal activity at the time, and therefore he shouldn't be able to pursue me for damages that arose out of whatever I might have done to him, okay? And another quote from an old case, the Hall versus Hebert case, 1993, from the Supreme Court. Quote, "It will be available wherever the conduct of the plaintiff giving rise to the claim is so tainted with criminality or culpable immorality that as a matter of public policy, the court will not assist him to recover," right? So the court's not going to provide assistance to somebody who's been involved in an illegal act. The case of Baird versus the Queen, 1992, discusses this exact principle. This is cited on your slides for you. Baird and his girlfriend had checked into a hotel after they'd been involved in a heist the day previous. So when they checked in, the clerk at the hotel had no idea that they'd been involved in a heist. There had seen some hype on the news about a holdup that had occurred, and Baird and his girlfriend were splashing a lot of money around and in cash, and she thought this was a bit odd. So she called the police because she became suspicious. The police showed up and arrested Baird. They in fact did link him to the heist that had occurred the day previously, and in the interim they took the cash that they'd found and stored it in a hotel safe. So Baird confessed to some facts before he had a lawyer. He later got a lawyer. Police let him go eventually, and he was never charged because just the information they had was not sufficient to charge him. But later, Baird sues the government because he's trying to get his property back, essentially the cash that was stolen. And in this case, the court cited the doctrine of illegality to refuse the money being awarded back to Baird. Okay? So then the fourth defense that we're looking at is contributory negligence. This is a pretty important defense from the standpoint that you see it raised a fair bit in cases. And in fact, a couple of cases you've already looked at this term. That you have looked at this term, I believe have dealt with this issue of contributory negligence. So contributory negligence can operate as a whole defense or just a partial defense. And essentially it comes into play where the court has found that the plaintiff has failed to take proper care for his or her own safety. And so therefore they've somehow contributed to the injuries they sustained as the result of a negligent act. In Ontario, it's the Negligence Act that covers this area of the law. And basically how it operates in a case is if the plaintiff is found to have suffered some kind of negligence against them and they are awarded damages from the defendant, the court will actually reduce the entire damage award based on the plaintiff's liability or the amount of the plaintiff's liability. So if they find that the defendant was liable for negligence and they ordered an award of $100,000, if they find that the plaintiff was 20% contributory negligence, then that means that the defendant actually only has to pay $80,000 of the full $100,000. because the other $20,000 in damages was really the plaintiff's own fault, okay? So an example might be if it's a snowstorm outside, or a snowstorm has just recently ended and it's icy patches on the sidewalk, and a plaintiff is walking down the sidewalk drunk and in stiletto heels. And say they slip outside of your property, which hasn't been cleared yet from snow and ice, and you haven't put salt down to alleviate the ice on the sidewalk. If they slip and fall, then perhaps you could be liable under the area of occupier's liability, which we come back to shortly. When this goes to court, if they've claimed occupier's liability and saying that the person in control of that property owes them damages for slipping and falling, the property owner's or occupier's defense might be, hang on a second, yeah, I didn't salt my property yet, but you were drunk and you were wearing stiletto heels. So part of that's on you, right? Like if you were wearing winter boots, maybe you wouldn't have fallen and slipped. And so in that case, the court might say, you know, I think you're right. And I think the plaintiff is negligent in some way. They have contributed to the act that has befallen them. And so homeowner or property owner, you're going to be liable for so many damages, but the plaintiff has to bear the burden of some of that negligence on their own as well. Okay? This principle was discussed in a 1994 decision from the Supreme Court of Canada, Galask versus O'Donnell. And essentially this is where the court identifies that an adult passenger choosing not to wear the seatbelt in somebody else's car will likely be entirely liable, or maybe partially liable, for any damages that have occurred as a result of an accident that the driver of the car got them into, okay? So adult passenger is probably going to be fully responsible for that, if not largely responsible for that, those damages. If it's a child passenger, though, things change, because children are not expected to know what's reasonable and what's not all the time, and what's safe and what's not all the time. So therefore, the driver of the car would probably be fully liable for any damages that occurred to a child passenger, where they might not be to an adult passenger. The parent of that child, if they agree to let that child go in the car without a seatbelt, there perhaps could be some contributory negligence on behalf of the parent of the child, okay? So a quote that comes out of that case about this scenario exactly is this: a driver of a motor vehicle owes a duty of care to his passengers to take reasonable steps to prevent foreseeable injuries. And that duty of care extends to ensuring that passengers under 16 years of age wear their seatbelts. Passengers and drivers have a duty to ensure their own safety in a car by wearing seatbelts, and a failure to do so will result in an assessment of contributory negligence. Children under 16 require guidance and direction from parents and older persons, which must extend to ensuring that they wear their seatbelts. 2 or more people may bear that responsibility, but one of those responsible must also always be the driver of that car. So when a child is injured as a passenger, the driver of the car is always going to bear some responsibility, though it could be split. Where an adult is injured, the driver is very unlikely to have to bear any responsibility, okay? And it's mostly going to fall on the shoulders of that adult who was injured, on their own shoulders, because they chose not to buckle up. So I believe this is the last defense to discuss with you, and it's joint tortfeasor. So this is essentially where a court has found that one defendant's liability will be limited because there was another defendant in the mix as well, a co-defendant or a joint tortfeasor. Recall that a tortfeasor means wrongdoer in the area of tort law, right? So this essentially is where co-defendants are found liable. An example, say you slip and fall on someone's driveway. Let's not assume there's stilettos in the mix here. Let's assume that you were wearing proper snow boots when this happened. You slipped and fell on someone's driveway, whether or not there was a crack in the driveway that made you lose your footing, or there was ice so it hadn't been maintained. And once you fall, you roll onto the street, and as a result of that, you get hit by a car going by. There could be two joint tortfeasors in this case. The property owner from whose property you originally fell, and then the person who's hit you in the car as they're driving by, right? So in circumstances like this, the court will determine what percentage of liability falls to each defendant. So they're going to say, okay, property owner or person in control of the property where you slipped and fell, you're going to be 30% liable. Driver going down the road, you're going to be 70% liable for the damages. So they basically just split the damages in a way they see fit according to the facts of the case. All right. Co-defendants are most often found to be, quote, jointly and severally liable, end quote. So that quote, jointly and severally liable, is a common phrase that you'll see in court cases. And essentially this means that co-defendants, you are equally liable for the full amount of money. So even if I found defendant A only liable for 30% and defendant B only liable for 70%, if defendant A doesn't pay out their 30%, that's not fair to the plaintiff who suffered harm. So they can go to defendant B to claim the entire 70 plus 30, so the entire 100% of any liability that's owing to them, any damages owing to them at all, okay? What it means then is B can turn around and sue A to get that money back that they've paid on their behalf. Okay, so jointly and severally means you can go after, as a plaintiff, both defendants to get the payout, or even just one defendant to get the entire payout that's payable to you. And then that takes us to the end. So those are the concepts of defenses to negligence as they apply to negligent acts. If you have any questions, please feel free to ask. We'll have a class discussion on this on Friday, March 27th from 10 a.m. to 11 a.m., a live class discussion. Also, there's reading available for you to read through, and the slides are there as well too for you to review. Okay, talk soon. Take care.